Property owners think having an easement means giving up ownership of their land, but here's what's really happening. You're only sharing specific rights, not ownership itself. I'm Tiffany Weber, real estate attorney in North Carolina at Thomas & Weber. I've done thousands of closings in the Lake Norman area, and I'm here to tell you exactly what you need to know about easements. In this video, I'm going to break down exactly how easements work, what rights you're actually giving up, and what you can and cannot do on your property when easements are involved. If you're buying or selling property in North Carolina, this video is for you. And if you want more information on real estate law and transactions, hit the subscribe button. Now let's dive in. Section 1, what an easement actually is. The number one misconception I hear about easements is that people think they're giving away ownership of their property. Here's the legal definition straight from law school. An easement is the non-possessory right to use the land of another. The key words here are right to use. Nowhere in that definition does it say ownership. Think of property ownership like a bundle of sticks. Each stick represents a different right. The right to build, the right to exclude others, the right to sell. When you grant an easement, you're only giving away one or two sticks from that bundle, not the whole thing. So for you, this means when someone has an easement on your property, you still own the land. You're just sharing specific usage rights. Section 2, the most common easements you'll see. Let me break down the easements you'll actually encounter when buying property. First, utility easements. These are usually located across the front and sides of your property. Duke Energy, cable companies, water companies, they need access to their lines and equipment. Here's what most people don't realize. If you see a utility easement on your plat, that company can park their trucks there, dig there, and maintain their equipment there. You can't block them, and yes, they can mess up your lawn if necessary. However, usually the easement language requires they fix anything they mess up. Second, right-of-way easements. These are for roads, driveways, or pathways. In lake communities, I see these all the time for community access to the water. You might have neighbors walking through your lot to get to the lake, and that's perfectly legal if there's a right-of-way easement. Third, drainage easements. These handle stormwater runoff. I actually owned a home with a drainage easement across the back, and it prevented flooding. It was actually beneficial. Section 3, what you can and cannot do. This is where people get confused about their rights. What you cannot do in an easement area: build permanent structures, plant trees that would obstruct access, block or prevent the easement holder from using the area, put up fences that interfere with the easement purpose. I have a family member who gets upset when the utility company works on his lawn. I tell him, wait a minute, they have an easement there, they can work there. You cannot stop them. After all, you do want utilities at your house, right? What you can do: use the area for purposes that don't interfere with the easement. Maintain landscaping that doesn't obstruct. In many cases, park vehicles temporarily if it doesn't block access. The key is this: your use cannot interfere with the easement holder's rights. Section 4, easements that aren't on your plat. Now here's where it gets interesting. Not all easements show up on your plat. Prescriptive easements happen when someone uses your property openly and continuously for years without your objection. Think of a neighbor who's been using your driveway for 20 years. They might have earned a legal right to continue. Easements by necessity occur when property gets divided and access becomes necessary. I had a case that went to the North Carolina Court of Appeals where my clients had an easement 5 different ways: by grant, by prescription, by necessity, by implication, and by estoppel. Here's what you need to know. These easements can be declared by a court and then added to future plats or to the public record. Even if your current plat looks clean, there could be easement issues lurking. Section 5, protecting yourself as a buyer. The bottom line is this: review your plat before you make an offer, not at closing. Look specifically for utility easements and where they're located, right-of-way easements that might affect your privacy, drainage easements that could impact your landscaping plans, any easements that reference deed books for more details. If any easement is a deal breaker for you, find out before you put down non-refundable money. In my practice, I see buyers get surprised at closing because they never looked at their plat and they didn't get a survey. Don't be that person. Let's recap what we covered. Easements are usage rights, not ownership transfers. Most common types of easements are utility, right-of-way, and drainage easements. You can't block easement holders, but you still own the land. Some easements don't appear on plats until they're legally established. The bottom line is, if you understand what easements actually are and review your plat or survey carefully, you can avoid surprises and make informed decisions about your property purchase. If you found this helpful and you want more information on real estate law and transactions in North Carolina, make sure you subscribe to our channel. And if you're buying or selling property in the Lake Norman area, you can find us at thomasandweber.com. I'll see you in the next video.